Civil Judge, Junior Division and Law Examinations in English language. Law of Evidence, Examination of Witnesses. Part 4, Chapter 10, Sections 140 to 168 of the Bharatiya Saksha Adhiniyam is the topic for discussion today. Section 140 to 168, totally 29 sections under BNS, whereas this chapter, Examination of Witnesses, was studied in Part 3, Chapter 10, Sections 135 to 166 of Indian Evidence Act, totally 132 sections. So, in this new enactment, 3 sections have been reduced for the reason earlier sections 141 to 143, these 3 sections dealt with leading question. These 3 sections have been clubbed into one section 146 relating to leading question. In those 3 sections, what is leading question, when leading question cannot be asked, when leading question can be asked, it was shown in 3 sections separately in Indian Evidence Act. All the 3 sections have been clubbed into one section, that is section 146 under Bharatiya Saksha Adhiniyam in the new enactment. Further, one more section was reduced in section 165 and 166 of Indian Evidence Act have been clubbed into one section, that is 168. Previously 168 and 166 dealt with power of judge and jury respectively with regard to questioning of the witnesses. But here the section 165 and 166 have been clubbed and reappeared in section 168 of the Bharatiya Saksha Adhiniyam. Dear friend, so far as these 3 new criminal law enactments are concerned, you need not worry. There won't be any drastic changes. The changes are very little, subject to socioeconomic changes to meet the day-to-day requirement. And you students need not worry that criminal law, IPC, CRPC and Evidence Act were totally removed. They are no way useful. But those 3 enactments have been reproduced in all the new 3 enactments. Bharatiya Saksha Adhiniyam, that is for evidence. Bharatiya Nyaya Sanhita, that is for IPC, and Criminal Procedure Code, that is BNSS, Bharatiya Nagarik Suraksha Sanhita. But whatever content, whatever subject was there in previous enactment has been reproduced in the new enactments with some slight changes. So you need not worry that the old law is no more valid, because our laws are more than 200 years old. Indian Penal Code was passed in 1860. Now more than 160 years, 260 years elapsed. Indian Evidence Act was in 1872. More than 250 years elapsed. These enactments, Evidence Act, IPC, CRPC, successfully in force for more than 200 years. So whatever was there in old enactment has been reproduced with some slight changes, subject to some developments and socio-economic changes in the present day. So suppose you friends, you are asking me to upload freshly these IPC and CRPC, and IPC and CRPC I uploaded good number of lectures. For time being, I will take up these new criminal laws. Evidence Act I have almost completed, because the 2 more topics are to be taught in this Evidence Act. This examination of witnesses is last but one chapter, and one in previously some burden of proof and some other one or two topics were left. I will take up in 2 or 3 more classes and will complete this subject. Then I will proceed to um, IPC and CRPC. I will give you compare to study of IPC and BNS, CRPC and BNSS, so that you will get some idea. For time being, you can make use of my lectures. I am receiving so many comments requiring various issues, but I will give clarification in next lecture. General lecture. I request you to follow my general lectures, wherein I have wonderfully enlightened you. Those lectures are my general lectures are common for all the students, first year to final year, and candidates appearing for judicial service exam. So there is a flash news from reliable source that the Supreme Court of India I have a judgment has given judgment. No, as on today, immediately after LLB, the candidates can appear for the civil judge junior examination, but the government, as on today, the examination process in okay, and let them it will continue in future. Civil judge examinations, there must be minimum 3 year bar standing. So accordingly, after LLB, you will have to enroll as advocate, practice for 3 years, then only you will be eligible for this. In my previous lectures, I told you, big try complete, watch all my lectures, join some coaching center after immediately after LLB, and go to court directly at judge. That is the rule as on today for up to 20th May, but it is learned from most reliable sources that the Supreme Court gave judgment. Uh, 3 years standing is condition precedent to appear for the judge's post. So anyway, dear friends, if you follow all my lectures and you could take coaching for judicial service 6 months, I am hopeful that you will be able to go through. So as these are whatever I say in the beginning, they are very important things. Don't think that I am telling something irrelevant. No, we have to discuss about this subject, examination of witnesses. The entire any judicial process is based on witness only, evidence only. Without evidence, no court will be a judicial body or quasi judicial body will be able to give judgment. In the absence of a proper source of if law is not there, law is not clear, the court can give judgment exercising its inherent power. If legislation is there, it may follow some precedent or that is previous judgment of the court. If precedent also is not there, it may follow the custom. When in sources of law in legal theory, I explained all these things. When in the absence of any source of law, the judge will be able to deliver judgment, uh, keeping by exercising his discretionary power or inherent power provided to conferred on the courts, subordinate courts to high courts and Supreme Court under various CPC, CRPC provisions and constitutional provisions under Article 226, 227, Article 32, 136, etc. But if evidence is not there, no judge will be able to give any judgment. That is why to get evidence, witnesses are to be examined. Basing on the evidence given by the witnesses, the court will come to some conclusion and will be able to give the judgment. So these who are the persons qualified or competent to give evidence, who are not qualified or not competent to give evidence, whether there is no any standing rules. These are the persons competent to give evidence, these are the persons not competent. The court, taking into consideration various aspects, will decide whether a particular person is competent to give evidence or not, and who can be testified, who cannot be testified. All these aspects I explained in the last class. This class, how we will examine the witnesses is the topic. So section 142 to 168, totally 29 sections lay down various provisions relating to examination of witnesses. Examination of witnesses. Today we have to discuss about these sections, section 140 to 168. Dear friends, I told you in the previous classes, in any textbook there will be any subject is based on some, if it is codified, it is based on some codified enactment. Evidence Act, Indian Evidence Act is now based on Bharatiya Saksha Adhiniyam containing 170 sections. Okay, but some one single section we study one single section as big chapter. Some group of sections put in one chapter, we study as one chapter. For example, section 32 in Evidence Act, now section 26 in Bharatiya Saksha Adhiniyam speaks about dying declaration and persons who cannot be called again, who cannot be called to testify, to give evidence. That topic we will study. That one section there is a lot of literature, but every section is almost having a lot of literature. But so far as the examination point of view is concerned, one section we will have big subject, in some group of sections will be one. Similarly, previously I told so many. For example, section 6, section 6 in Indian Evidence Act, section 4 in this Bharatiya Saksha Adhiniyam deals with res gestae. One single section itself we study the entire chapter. So that is why don't worry, if though there are 29 sections, you need not worry, you need not by heart all the sections. Very limited number of sections you have to remember and study in deep, and other section we have to just study in brief. Some sections, very few sections you have to study in detail. For more number of sections you have to study in brief. So that is why, what are the single sections which are more important, dealing with more important topics, we will know. So here, in this chapter we discuss about some important aspects. Number one is examination of witnesses. Under that, what are the various stages in examination of witnesses? Each and every point I will explain in detail. There are 4 stages in examination of witnesses. The examination in chief or chief examination or general examination, cross-examination, re-examination, re-cross-examination. What are these? What is leading questions? I will tell you later. Next important topic for discussion is section 142 speaks about the various stages about examination of witnesses. I will explain in detail. Second topic for discussion is second important section is section 146, leading questions. Leading question. What is leading question? Previously, section 146 of section 146 of Bharatiya Saksha Adhiniyam deals with these leading questions. Previously, section 141, 142, 143, 3 sections dealt in Evidence Act dealt with leading questions. 141, what is leading question? 142, when leading question should not be put. 143, when leading question can be put. These 3 sections are clubbed into one section, that is section 146. Under section 146, we study about leading question. Leading question, I tell you in one sentence. Leading question means the question should not contain answer. So we should not give any clue. When lawyer puts question to the witness, he should put the question properly, normally, but he should not put questions in such a way that the witness will be able to answer the question comfortably, saying yes or no. That is what leading question. Details we will take up later. Next, third one is hostile witness, section 157. Hostile witness or friendly witness or adverse witness or unwilling witness or unwillful witness, all are same. So here, hostile witness mean, civil litigation, 2 parties are there. One is plaintiff, other is defendant. If it is a petition, if it is a plaintiff written statement, A person who files plaintiff is called plaintiff. The person who has to file written statement is called defendant. So this is, if this is the case in district court, it is filed in a petition type. Suppose wife and husband matrimonial case, restitution of conjugal rights or divorce or maintenance, then the aggrieved party files petition. That petition, the person who files petition is called petitioner. It may be husband or wife. The other party is called respondent, petitioner and respondent. So either from so here either plaintiff will or petitioner will bring the witnesses of their witnesses to to give evidence in their favor. Similarly, defendant side or respondent side also, they will bring witnesses to give evidence in their favor. Suppose if the plaintiff brings one witness to give evidence in his favor, suddenly that witness, instead of giving evidence in his favor, gives evidence against him or in favor of opposite party. That witness is called hostile witness. He turned hostile. So the person whom we bring, the person who is brought to do good, he comes does bad, that witness is called hostile witness. Suppose I am plaintiff, I brought two witnesses. One witness, while giving evidence, speaks against the opposite party instead of me. That means he has become hostile. He has become willful witness. He has become adverse witness. So that just means the witness who is expected to speak in our favor happens to change suddenly and give evidence against us or in favor of opposite party. That witness is called hostile witness. Section 157 of the Bharatiya Saksha Adhiniyam deals with this particular thing. Next important section for discussion is impeaching credit of witness. Impeaching credit of witness, section 158. Impeaching credit of witness means, suppose if the plaintiff's witness speaks against him or speaks in favor of opposite, that is what is called hostile witness. Then the party can contradict and question him in order to impeach his evidence. Suppose I am a plaintiff, I brought one witness, but I thought that he will give evidence in my favor. But suddenly he changed. Unexpectedly, suddenly he changed. Instead of speaking in my favor, he started speaking against opposite party. Or he is speaking against me. Then I doubt. Immediately, if it is in a chief examination time, I can interfere with the permission of the court and question him to say that what he is saying is wrong. So, in order to make the evidence given by the witness not correct, not proper, not worthy, not genuine, that if the party questions or advocate questions the witness, whatever he is saying is not right, wrong. He changed his mind suddenly. He was bribed by opposite party. He accepted something. He promised to accept something or telling something. So immediately he can do it. If it is in a examination in chief time, his own witness turned hostile. Immediately the affected party, with permission of the court, can question him, and no, his evidence is not correct. What is the various issues we will take up in the next chapter. That is what is called impeaching credit of witness. In cross-examination also, when opposite party he said something positive in examination in chief, the opposite party will question in anything. That is then. So if my witness speaks against, I can impeach his witness. Suppose if my witness speaks correctly, everything okay. If opposite party wants to contradict the evidence of my witness, that is also called impeaching credit of witness. So impeaching credit of witness means to render the witness given by the witness wrong. It is untrue. It is false. It is unworthy. It cannot be admissible. So that is contradicting the evidence of opposite party is called impeaching credit of witness. It is taught under section 158 of the Indian Evidence Act. Next, important topic for discussion is refreshing of memory. Refreshing of memory. Refreshing of memory means here in judicial proceeding, whether civil proceedings or criminal proceeding, during the process of examination, chief examination, cross examination, some new points may arrive at. In that process, some new witnesses may be in course of questioning answer, some new names may come out. So and so person knows that. Then the court may order that particular person to come and give evidence in the during the process. One document may be required to be produced, and so during the process some object may be required to be produced, and process to compel the appearance and production of things. In that chapter in CRPC I explained various issues on this question, dear friend. So when basically some required persons are necessary to give evidence. When the required persons are giving evidence through the process of chief examination, cross examination, re-examination, etc., in that process some new persons may be required to be produced in the court, and some new experts are required to be produced in the court, or some new documents are required to be produced, and the documents may be in the possession of some private person or a person of some official. They may be produced or they may not be produced. If cannot be produced, what the position? If that person doesn't like to produce, what is the position? All these aspects we will discuss during the course of this examination of witnesses. Accordingly, section 162 of Bharatiya Saksha Adhiniyam deals with this the most important topic, refreshing memory. Refreshing memory in the sense, suppose we are bringing a particular person to give evidence. So suppose there are some doctors, lawyers, some doctors, lab technicians, pathologists, postmortem report, who give postmortem report, some pathologists or fingerprint analysts, nurses, doctors, all these persons may be required to attend in this. So those persons daily they come across so many. So for example, police officer regularly they come across so many cases. Nurses come across so many cases. Doctor come across so many cases. A gynecologist, lady doctor come across so many cases. In course of time, to find out the genuine witness evidence, some doctors may be required to come to court and give evidence, and any other person who can be called for evidence, who cannot be called for evidence, who can be called by fulfilling some conditions. All these aspects I explained in the last class, but here some expert opinions may be there. In the meantime, some fingerprint expert may be called, some postmortem expert may be called, some handwriting expert may be called, some nurse may be required to come, or doctor may be required to come, registrar of registration may be required to come, so many things. So when we call such a person to come and give evidence, though sometimes they will be able to remember and they give evidence, that is called so if they is okay, if they are forgot the thing, they will be given some time, if that provided it is some reasonable gap should be there. If it is a long gap, suppose if a delivery took place from 20 years, if that the doctor is required to give evidence, it is not possible. Some short time, reasonable time. What is short time? What is the reasonable time before or after the occurrence of that evidence? Then the person's experts may be called. Sometimes for general opinion also expert opinion may be required. If this is the case, how it would be? Some expert may be called and asked to give evidence. So these are that expert suo motu may be able to give evidence, or he may require some document, he may require some writing, either his own document or some other document. All these things will be there. These things you have to study in refreshing memory. So in this lecture we have to discuss the order of preference, how the witnesses are called for, how the parties attend, how the examination of witnesses process will take place, and what is a leading question, what is hostile witness, what is impeaching credit of witness, what is refreshing memory. On these three questions, examinations of witnesses, essay question may be asked, leading question may be asked, a short note question, a hostile witness may be asked a short note question, impeaching credit of witness may be asked at short question, and refreshing memory may be asked at short question. These topics may be asked at either short question or essay question also they may be asked, depending upon the volume of marks you will have to present the answer. So dear friend, there is a lot of case law. I find it difficult to tell you the various case laws. Now this examination of witness we have to study from section 142 to 168, total 129 sections we have to study. Now let us discuss about, we forget about Evidence Act section numbers. We have to rely on the section numbers of Bharatiya Saksha Adhiniyam. Now first section is section 140. Order of production and examination of witnesses. Suppose when whether it in a civil case or a criminal case, the procedure is the plaintiff will file a plaint making allegations on the defendant. Then after when the case is registered, the court will issue summons to the defendant to present the counter or written statement. Then after the preliminary process is there, the parties will be called. The parties will be required to come to court on a particular day. The plaintiff will have to come with his advocate and witnesses to give favor, and similarly defendant will come with his advocate and his witnesses. So plaintiff side witnesses are there, lawyer is there. Defendant side witnesses are there, lawyer is there. Similarly, petitioner side lawyer is there, witnesses are there. Respondent side lawyer is there, witnesses are there. This is civil litigation. In criminal case, public prosecutor who will have to prove the case. Suppose a person is accused, the person is alleged to have committed an offense. It may be murder or rape or theft or robbery, whatever it may be. When he is brought before the court, the accused, the public government officer, public prosecutor will be there. Public prosecutor will try to convict the person. For in order to convict that person, accused person, the public prosecutor will bring the witnesses. Similarly, the accused will engage some lawyer, that he is called defense lawyer or defense counsel, and from to protect his interest he also will bring some witnesses. Both the parties will have lawyers and witnesses. In case the accused person has no lawyer, the court will have to provide a lawyer at government expenses, and that provision is there. In civil case, the defendant has no lawyer, and if he is a pauper, then a pauper suit is there. I explained in CPC. That is as per that government will provide a lawyer. So the both parties will be there. Both parties will, the order and production of examination of witnesses. So this the order and production of witnesses is governed by, regulated by the civil procedure code and criminal procedure code. Now criminal procedure code has been was repealed, and new enactment Bharatiya Nagarik Suraksha Sanhita 2023 was there. Originally, criminal procedure of 1973. Originally, CRPC was codified in the year 1898. Subsequently, recodified in 1973. And today, the criminal procedure code was abolished, and in its place, Bharatiya Nagarik Suraksha Sanhita, new enactment has come. So here, for civil case, the procedure of CPC is followed. In CPC, the Code of Civil Procedure 1908, the rules of Order 18, Rule 1, 2, 3, and Order 41, Rule 16. So according to according to order 18, rule 1, 2 and 3, and order 41, rule 16, how the procedure in civil court is followed, it is prescribed. Suppose if there is no, if any particular case, there is no procedure to that effect, the court has the discretionary power to follow the procedure that is there. So here, as per the procedure, how the what procedure, according to what procedure the proceedings of examination of witnesses take place is governed by. So according to order 18, rule 1, 2, 3 of civil procedure code, the proceedings will be started. If it is a criminal case, according to if it is civil case, order 18, rule 1, 2, 3, and order 41, rule 16. These, according to these four rules, the procedure will be followed. If it is a criminal case, according to chapter 19, 20, 21 and 31 of Bharatiya Nagarik Suraksha Sanhita, according to whatever sections are there in these chapters, according to that procedure only the proceedings will be started. This is what order 140 of the tells. So here, if there is no proper procedure, then the court has the power to. The court has the power. Similarly, when a plaintiff filed a plaint, then the court will order the summon the witnesses, summon the opposite party to file counter, that is written statement, and take it. And when the next one is who should be called first, who should be called later, also is prescribed here. Here, we suppose the cause of action is the one more point to be taken into consideration. So here, the person who suffered, who is aggrieved alone, he will have cause of action to approach the court. Suppose the buyer and seller is there. Seller received money and did not give property to buyer. Buyer is aggrieved. Buyer and one in a contract, two parties are there. One party breaches the contract, other party will be aggrieved. The aggrieved will have the cause of action to approach the court. The person who approaches the court, who moves the court, has a burden to prove. This burden of proof is one important chapter is there. This burden of proof, next class I will take up this burden of proof both in English and Telugu. Dear friend, please note that I delivered up to nearly 150 lectures in English only. I never had idea that lectures should be taught in Telugu. After that, at the request of the Telugu speaking students, since my mother tongue is Telugu, I started uploading Telugu lectures also. But even though I have started uploading Telugu lecture, today I upload Telugu lecture first. Immediately in a day or two, I am uploading the English lecture. Dear friend, thank you very much for your lot of cooperation for reaching my channel to very good extent. There are about 18,800 subscribers are there. The response is very good. I request you to make use of my lectures because I am taking lot of strain and pains to deliver one big chapter in one class. I am undergoing hard labor sometimes. Some lectures can be taught easily, but some lectures requires a lot of preparation. So I wanted to for the cause of student, I am taking lot of interest, initiative to do justice to my student friends. So the lectures are somewhat lengthy, but don't worry. If you can't listen entire lecture, you simply download it, and whenever you are free, 10 minutes, 15 minutes like that you take, because I won't be able to teach in 10 to 15 minutes because I have taken giant project. I have to complete so many subjects, and immediately I will take a new criminal laws compared to study, but the subject is same. Because friends, in the next lecture I will give you various important points regarding books, examination preparation, the greatness of our legal profession. Now and then I told some personal matters also. I will tell you how you must be careful, and you must correct yourself without relying on anything. All these things I will give some general lecture. Now please don't neglect my general lectures. They are very important. So now these are the various aspects we have to study. So here joint owner. Suppose owner, there are two or more joint owners are there. Two or more joint owners, one joint owner can file a case against the party. Suppose the two or more persons purchased a flat from a builder, but the builder, two or three persons are buyers. One builder is only one person. But if the builder is not doing his job, he is not giving possession of the property, then though the buyers are two or more, one alone can file a suit against the builder. Then the power of attorney by one joint owner to other is not necessary. Suppose the owner is a single person, if he wants to sell his property, he can give power of attorney to his son or near or dear. He can give power of attorney to anybody. Suppose he is a single owner. But he is also having joint owner is having equal title, joint title. In such case, power of attorney need not be given. These are the various issues relating to section 140. Next, section 141 speaks about power of the judge to decide admissibility. Suppose when witness comes to the court and gives witness, he must be a qualified evidence. Whether the particular person is qualified to give evidence or not, the court has to decide. We must have causal connection. Connection with that particular case, then only the court will allow any person to give evidence. Sometimes some witnesses may be there. There is no any rule. Just like Contract Act, minor is not eligible, unsound is not eligible. Such rules are there. But for giving evidence, there is no any rules. Because a child can give evidence, a person, a too old man can give evidence, a person who is undergoing treatment can give evidence, provided it is court should decide, could test him whether he can give evidence. He will be able to speak evidence, though not able to give evidence, by nodding his head, by gestures, by other process, whether he can give evidence or not, it is the court to decide. But prima facie, the child he is not qualified, unsound he is not qualified, is what we cannot say. Whether a particular person can give evidence or not, the court can decide. The court has power to decide. So when the court allows any evidence, it must act very carefully whether a particular person giving evidence is competent or not, he is qualified or not, then when once he want to, first of all, he should be qualified and competent person. Secondly, what he speaks is relevant, must be relevant. It must relate to fact and issue. It must relate to fact, relevant fact. What is fact? What is relevant fact? What is fact and issue? All these issues I explained in the beginning chapters. So he must give that. So so admissibility. The question of admissibility is admissibility of law. So that is why the judge must be very careful in allowing the person. For example, I tell you, dear friend, in the Section 5 Indian Evidence Act, then the general rule, only relevant evidence is admissible. Section 5 Evidence Act is now Section 3 Evidence Act. Section 3, that is general rule. Only such evidence which is relevant to fact in issue or relevant fact is admissible. But there are so many exceptions. In Evidence Act, Section 6 to 55. 51 sections, exceptions are there. In new Bharatiya Sakshya Adhiniyam, section 4 to 50. Section 4 to 50 means 47 sections are there. The exceptions are there. For every exceptional section, there are so many subsections. 6, 8, 9, 10. All these things I told in the class. So, the general rule is one. Exceptions are so many. The general rule is section 3. But the exceptions are section 4 to 50, 47 section. For every one section, there are subsection. In subsection, there are clauses. there is lot of confusion, dear friend. That is why don't think that it is not so easy to have to masterize single subject, single bare act. So it is very difficult to study in detail even one bare act as for one particular subject. So you have to it is not so easy, but that is why you please note that judge may see the book to dictate the judgment, lawyer may see the book to prepare the argument, even teacher may see the book or PowerPoint presentation to teach the class, but it is only the student to write the exam without seeing anything. So for that purpose, the student must have to by heart it. So at this age of beyond after graduation, the after when you became major, it is not difficult for you to remember by heart the thing. In childhood only, in high schooling level only, you will have that capacity to by heart everything. So that is why don't worry, you work hard, prepare working notes, and these certain things I will explain in detail in general lecture. Yeah. So suppose when evidence is there, suppose somebody wants to prove the dying declaration, presents a dying declaration. Suppose he wants to speak about dying declaration, a person who was about to die something, according to section 26 of this present act or section 32 of old act. If you die, if you are telling, you should say that you are presenting dying declaration before the court, that person must die. You have to establish that the person who made dying declaration died already. That is there. So, sorry, according to section 33, the persons may be asked again and again. First time one person came and gave evidence. Subsequently, whether he is alive or not, we don't know. Whether he is in country or went to America or Canada or not know. Whether he is abscond, whatever, it is not possible to defend. So 32 speaks about confirmed death. But 33, whether he died or not, he also cannot be found. All these aspects are explained in detail in section 32, section 26 and 27 of the Indian evidence, this Bharatiya Saksha Adhiniyam previously. So, suppose you want to produce some primary evidence is required to be produced. Primary evidence is main evidence. You have to establish your evidence with written proof, written document. In case the written document is not there, you have to establish that written document is lost, written document is with some party, some official, it cannot be brought back, and you have to prove that the original cannot be produced at any cost. Then the copy of the document can be permitted. When original evidence is not there, documentary evidence is the main evidence. In the absence of documentary evidence, oral evidence is accepted. In the absence of original document, copy of the document can be permitted. So when once you produce secondary document, you should establish that the original document cannot be produced. These are the various issues the judge will take into consideration while accepting, while entertaining the evidence of a witness. First of all, the witness must be qualified to testify. He is a qualified witness to give evidence. And secondly, he must be whatever he says should be relevant and consistent to the case. So these are the various aspects under section 141 to be discussed. Section 142 speaks about examination of witnesses. Examination of witness. So the entire procedure in previous section, so there are, it simply names chief examination, cross-examination, re-examination, re-cross-examination. So section 142 gives you full details of the first in examination of witnesses, what is the procedure. First, chief examination or examination in chief or general examination to be conducted. Then cross-examination is conducted. Then re-examination is conducted. If necessary, with court permission, re-cross-examination is conducted. So, if examination in chief, cross-examination is certainly conducted, but third and fourth may be conducted, may not be conducted. For the conduct of re-examination and re-cross-examination, the prior permission of the court is necessary. So in examination of witnesses, the particular date is fixed for trial. Then the both parties are required. Both parties are required to present. Their advocates are required to present. Their witnesses also are required to present. So if it is a civil case, then the plaintiff side advocate will narrate, will explain the facts of the case in brief. Then the witness, the plaintiff side witness or petitioner's witness, side witness will be called. That witness will have to appear in a witness box and give oath or affirmation. Oath means by taking making I do here, I am speaking what all I speak is true. I do hereby promise in the presence of God, and putting his hands on Bhagavad Gita like that. And section 4, 5 and 6 are of Indian Oaths Act 1969 lay down the provisions relating to this oath. So some affirmation, those who cannot take Bhagavad Gita or any other book or thing, there is some other alternative process there to affirmation, and the witness will say. So first of all, the plaintiff side or petitioner side advocate will speak out the facts of the case facts of the case in brief. Then the plaintiff side advocate, plaintiff side advocate, lawyer will introduce his witnesses and call his witnesses to give evidence. Then plaintiff's lawyer will question his own witnesses. If the lawyer of the plaintiff questions his own witnesses, it is called examination in chief or chief examination or general examination. Generally, when the lawyer of a plaintiff or petitioner questions his own witnesses to favor his client, should not put all relevant questions, all connected to the case only. He should not put any leading question. Leading question means question that gives answer. Leading question is a question which gives answer. Where are you on 25th March so and so? Where are you? Where are you? Then that is the question. On 25th March, were you in Hyderabad attending some marriage? That is not correct. Yes, then he will say reply. So on 25th March, did you go to Hyderabad to attend marriage? That question. That is also question, but question itself gives answer. Just like in a play, in a drama, if the actor is not able to give speak dialogue from behind the screen, some prompting will be there like that. So the question, the witness himself will be able to answer the question, but the questioner, who is the person who is putting the question, the examiner should not put question in such a way that the witness will be able to answer the question. Simply, if he gives that is leading question. When once leading question is given, the witness can simply say yes or no. The leading questions cannot be put in examination in chief. So when the examination in chief is over, then immediately cross examination will be there. After examination of the plaintiff lawyer questions his witness, and immediately, if necessary, the opposite lawyer will come and question because to impeach his evidence, what he is saying is not correct, what he is saying what he is saying is not, to impeach his evidence. Then opposite party can come and question. If the opposite party question the witnesses of one side, questioning the opposite party by party or lawyer is called cross examination. In cross examination, the cross examiner can put leading questions. So leading questions cannot be put in when you want to question your own witness. You should not put leading question. When you want to put opposite party, you can put the leading question. That is there. Suppose you can put a leading question your own party to impeach. Suppose he became he gives wrong evidence against you, he became hostile, unworthy, then you can. So here, questioning of when one side party questioning other party is called cross examination. The for other side witness has the lie, this side lawyer may question, sometime with permission of the court this side party also may question that party, and he may ask, show me what you said is right or not correct, you show me the document, you show me the corroborated evidence, you show me the any written proof. He can also say, last time he said one thing and today he is telling anything. It is inconsistent. All these questions can be done. That is what is called cross-examination. Cross-examination is a very wide process. There are so many sections dealing with what, where, why, how, when the question is to be put, when the question cannot be put, what are the various situations. All these things will be there in cross-examination. Then after cross-examination is there, if necessary, if the party or advocate can, after cross-examination is over, again with permission of the court, the lawyer or party can question his own witnesses. That is called re-examination. And after that cross-examination side also, again cross-examination takes place once again. If new points are covered, new issues come to think, if new things come across, then re-cross examination also may take place. And if no re-examination is necessary, with the proceedings will come to an end with examination chief or and cross examination. If necessary, re-examination and re-cross examination and take place. So this is with reference to examination of witnesses. And next thing is, cross examination is a very long process. After that, the next topic for there are so many objects of cross examination. The purpose of cross examination: putting question to opposite party to impeach the evidence and prove that whatever he is saying is wrong. The purpose of cross examination is to find out the new facts. In cross examination, what you said is, last time you said something, this time you are telling anything, it is wrong, you can say. The purpose of cross examination is to impeach the evidence, to render the evidence unworthy, they render the evidence no value. This is the positioning. There are so many topics. We have to cover a lot of things. It is not possible to go in deep depth with each and everything. This is the significance of it. So sometimes cross examination is not necessary. Suppose the opposite party thinks that there is nothing to answer, there won't be any cross examination. If the matter already proved, there is no cross examination. If the court objects, the cross examination can be done. If the court believes beyond all reasonable doubt that the evidence given by this party is correct, then the court will not allow the opposite party to give evidence. So this is what is called. Next topic for discussion is leading questions. Leading question I already told you. Leading question is any question suggesting the answer which the person putting it wishes or expects to receive is leading question. Suppose leading question means the question contains answer. The question itself contains answer. The question itself contains some clue so that the other party, the witness, will be able to answer happily, and simply he can simply say yes or no. It is enough. Leading question, the word leading question is not defined. So in previously section 141, 142, 143, three sections. Section 141 Indian Evidence Act dealt with what is a leading question. 142 dealt with when leading question should not be asked. 143 dealt with when leading question can be asked. Three sections were allocated in Evidence Act, but these three sections are clubbed and put in one section, that is called section 146 of Bharatiya Saksha Adhiniyam. In leading question is that question wherein the question containing answer should not be asked. So here in cross-examine the lawyer and party cannot put leading question to his own party. But however, this lawyer or party can put leading question. Suppose the evidence given by his own witness is turned hostile. We brought our witness to give evidence in our side, in our favor, but this man unexpectedly giving evidence against us or giving evidence opposite party. If we keep quiet, we will lose our case. In order to protect ourselves, then in such case, with the permission of the, when our witness is giving wrong evidence against evidence, giving evidence against us, or against giving evidence favorable to opposite party, then either the lawyer or party with the permission of the court can cross-examine him in then itself immediately in examination in witness stage also he can question in such a way to impeach the evidence, stating that he turned hostile, he changed the party, he is giving evidence up to opposite party, not to us. Something happened. My witness must have been threatened by or unwillingness, coercion, or other thing. He might have bribed. He might have given some property or some other thing took place. So the court, we are asking permission of court, we can question our own witness. Well, in such case, the leading question can be asked. So these are the leading question can be asked. Suppose all these aspects relating to leading question and opposite cross examination for opposite witness, leading question can be asked. When leading questions can be asked, when leading questions cannot be asked as given in detail in that particular thing. Next one is hostile witness. Hostile witness also I told you in brief. Again I am telling. The term hostile means unfriendly or unfriendly. Unfriendly. The hostile witness is also known as unfriendly witness, adverse witness, unfavorable witness, or unwilling witness. When the party brings his own witness to speak in his favor, suddenly or unexpectedly he turns hostile and gives evidence against him or gives against opposite party. Such witness is called hostile witness. Then when he is giving hostile evidence in examination in chief time, the party or lawyer himself with permission of the court can contradict his evidence, that is impeaching the credit of witness. So this hostile witness is not hostile witness is not defined in either Evidence Act or Bharatiya Saksha Adhinayam. There are lot of cases. There is a lot of case law to decide what is hostile witness. In some cases, it is said that when once we cannot ignore outweigh hostile witness, that hostile witness is not the hostile witness we cannot ignore, outweigh the hostile witness. Sometimes the hostile witness may be correct. We give room for new clues and give. Suppose the witness party brings wrong witness. So earlier he agreed to give evidence in his favor. After coming to the court, his mind may change. No, for taking it is not. I don't like to give evidence against him because he is wrong. I don't like to give evidence against a wrong man, and he turns hostile. He wants to give genuine information. So according to this party, that is a hostile witness, but according to justice, it is right. So sometimes the court may accept that. Suppose when once a hostile witness is there, some corroborative evidence should be there. When once the witness tells against to this man or favorable to that man, he may be required to produce some documentary evidence. He may be required to produce some corroborative evidence, supporting evidence. that is there. So that is why in course of in prosecution time, when hostile if the witness turns hostile, that will give real cue for the for conviction of the person. In the interest of justice, this hostile witness also, evidence also may be taken into consideration, but we cannot say that hostile witness we cannot is not wrong. But whether it is a hostile witness, the party who brought the witness can contradict him to impeach the evidence, and he is given several opportunities to increase, and he may be required to produce documentary evidence. He can say that what he said earlier and now is absolutely different, inconsistent, and all these things he can tell. So here, this is the position with reference to. There are in Danu versus state of Tripura. In this case, what happened that to declare a witness to be hostile, there must be believable material prove the witness changed side by showing favor to opposite party. In this case, Danu versus State of Tripura, what said that when the party is telling that his witness is changed hostile, you should prove beyond reasonable doubts that he changed his side, something happened, what happened, you should provide some corroborative evidence. Your witness is telling wrong against you or favor against opposite party, whether it is right or wrong. If you say that, if you challenge it, you have to prove some substantial proof, either some documentary evidence or any other proof. But when he speaks, he turned hostile and gave evidence. We cannot ignore it. If the party wants to condone that, impeach that evidence, you have to establish some proof. He who challenges have to prove is what decided in this case. In another case, Srimati Mera Gopalakrishna Mudliya versus State of Maharashtra. In this case, it was held that mere fact that the witness turned hostile during cross-examination will not make him unbelievable altogether. It may support the hostile evidence may support prosecution. So when once a hostile witness is there, we cannot straight away ignore it. Sometimes the hostile evidence may be helpful to the prosecution to find out the real facts to convict the witness. So this is what given in this website. Now another section, one part for next topic is section 158. 158 speaks about impeaching credit of witness. Impeaching credit of witness. Impeaching credit of witness means when this side party or that side party tells that the evidence given by the opposite party is wrong, it is false, then to make the witness unworthy, the opposite party may question. Firstly, in first stage, when examination in chief or chief examination or general examination is taking, in that the plaintiff's lawyer or petitioner's lawyer will question his own witnesses, or then he turned hostile and telling evidence against opposite party, then immediately either a lawyer or his party, our witness is giving hostile evidence favorable to opposite party. Sir, we want to contradict him. In examination in chief itself, the question can be put. That is what is called impeaching credit of the witness. Impeaching credit of witness. Thus, one day you said like that, today you are telling like that, you show me documentary, what he is not telling is not correct. I will bring some other reasonable person, he will tell you about his conduct, character and all these things he can show. That is impeaching the credit of witness. Secondly, according to section 148, civil or criminal proceeding, So if I see any book, any content, I won't be able to teach well. So that is why, without seeing anything, I want to give clarification. See, this is important here. The impeaching credit of witness is provided with an opportunity for the reason that the greatness of evidence. For any case, for taking giving judgment of any case, civil or criminal, evidence is most important. Evidence is collected from both the sides. This party, if will give evidence from his side, and that party will give evidence, we will take the evidence of that party can be contradicted by that party is wrong. The evidence of that party can be contradicted by this party is going wrong. When the opposite party, the evidence given by one party is contradicted by opposite party, is called impeaching the credit of witness. What he is telling is wrong. Why previously it is inconsistent. It is. I want to show you some important persons who are having special knowledge. What he is this type of man. His character is that. That is why he changed his mind. He was influenced by money or bribe. He was influenced by. He was threatened. He may be injured like this. Suppose if he doesn't speak like this, the opposite party will cause harm to him or his family. Like that. So impeaching credit of witness means every party, this side party wants to win the case by providing proper evidence. That party will try to win the case by showing evidence. But both parties want to. This party tells that our evidence is right. That party tells that our evidence is right. But this party tells that evidence is wrong. That party tells that this type of evidence is wrong. So both this side party contradicts the evidence of that party, that is impeaching evidence. That side party contradicts his party, that is impeaching evidence in cross examination. In examination in chief itself, his own witness is speaking wrong against him or favor to opposite party, then immediately this party or his lawyer take the permission of the lawyer and contradicts the evidence. That is called impeaching credit of witness. Impeaching credit of witness means setting aside the credit of a witness, evidence given by the witness who turned hostile, rendering the evidence unworthy and to expose his real character. Impeaching credit of evidence means putting it aside, setting aside the credit of evidence given by the witness who turned hostile, rendering the evidence unworthy and to expose his real character. This definition refers to if my party, the plaintiff's party or petitioner party, turns hostile and gives evidence against him, then this party or his lawyer, with the permission of the court, will make some more evidence, in order to impeach, render the evidence wrong. That is called impeaching the credit impeaching credit of evidence. So according to this, there are section 158 of the Evidence Act is independently provide various provisions. There are four modes. Impeaching the credit of evidence. Suppose one party wants to impeach the evidence. Suppose the plaintiff or petitioner brought his own evidence. So then the plaintiff or petitioner brings his own witnesses to give evidence in his favor. But unexpectedly or suddenly, his own witness turned hostile. Then he has to prove that what my witness suddenly turned hostile and giving against to us, against us, are favorable to opposite party, he wants to tell. Then he should prove there are four circumstances, four modes. There are four modes, four ways to impeach the credit of the witness. Then to protect his interest, my witness is telling wrong evidence. So I am producing before you some experts who are having specific knowledge, special knowledge about the conduct and character of this witness. They will tell you they have good knowledge in relevant field. He will produce some other person to impeach the evidence. That is first thing. Second thing is, I will prove. In the meantime, at the time of my witness was right, he was speaking everything good, but in the meantime, he was bribed. He received bribe from opposite party, or the opposite party promised him to some bribe. He agreed to take the bribe, and he started giving false evidence. That is second thing. Thirdly, inconsistent. In what he said in previous time is one thing. Now he is saying another thing. Now I will, if necessary, what he is telling wrong, I will show some written document to that effect. In that way, he can impeach that evidence. Lastly, general character, general or immoral character. Suppose some bigamy or adultery is imputed. The question is with reference to bigamy or adultery or rape or something is there. Then to prove that some typical questions also may be asked. The questions that this person, this woman, when legitimacy of child is to be questioned, then this woman has immoral character. He had married extramarital relation with somebody. That type some immorality of a woman can be established. So that is why these are the different means to increase the credit of the witness. So this what this woman is tell is like is speaking like an ideal housewife, but it is not correct. It is what her conduct character is not correct. He is as a woman of some other character. What she gave evidence for money, she may do anything. She is not a genuine woman. To impeach her evidence, so this is the woman is not of that character. She is of has a lot of extramarital relation. General immorality of the or character also can be visualized in order to this. These are the various stages. And the next last point, important point for discussion is refreshing memory. So section 162 speaks about refreshing of memory. Section this has the following two section 163 and 164 also. We'll have the 163 with reference to documentation, whether a particular original document or duplicate documents, or whether his own document or the document in general, all these things are there. Section 164 relates to opposite party to impeach the evidence given by the refreshing memory. So refreshing memory means to recollect the memory. When examination of witness is there, chief examination, cross examination, re-examination, when the proceedings are taking place, and again this trial is closed and again the adjourned, again the witnesses examination, cross examination will come. In that process, some new persons may be required to come to court and give evidence. Some new documents may be required to come present. Some new persons may be required to come and speak out his property and may produce his documents. All these things, there are so many situations and circumstances are there. It is not so easy to remember all these things. Lot of situations are there. Lot of subclauses are there, exceptions are there. In every exception, there are so many clauses are there. That is why it is not so easy to generalize any single topic. So that is in for refreshing memory. When examination is going on, some new witness may be required to be produced. When a new witness is required to produce, the court will think whether it is relevant or not to call them. So if relevant, it is necessary to call him. Whether he can be called or not. If he is an ordinary man, he will be summoned to call. He is some judge or somebody, some permission of the higher authority to be taken. If he is some officer, some other care is to be taken. Some people, they cannot be called. All these things I told you. After that, in a criminal law also, process to compel afferent. In the first instance, they will issue summons. If that person doesn't come, they will serve arrest warrant. If he doesn't come, whereabouts unknown, proclamation will be there. If proclamation also not worked out, they will give they will seize the property. Different positions are there. Like that, the different positions are there in criminal procedure is there, civil procedure is there, civil procedure is there. So when it is done, for refreshing memory, some doctors may be required to come and give evidence, nurse may be called for, fingerprints expert may be called for, or that is expert opinions also may be called. When experts are required to come and give evidence, they come across the similar cases day to day. The police officer will have so many cases every day. Fingerprint experts will have so many cases so regular life. A nurse will have witness so many deliveries regularly. A gynecologist witness so many deliveries regularly. When some experts or analysts or post-mortem pathologists are called, they sometimes they may be able to give evidence so quickly if they remember. If they do not remember, sir, this type of cases I have seen so many hundreds or thousands, I won't be able to remember. Then you please remember, this is very important case. We are giving you some time. Some time is given. So some time is given. The person, doctor or lawyer, doctor or nurse or any technical expert may be given time to refresh the memory. In for refreshing memory, there are three things: observation, recollection, and communication. Between observation means when he can tell if he observed a particular thing, particular aspect, particular document he observed, particular document he has seen, that is observation should be there. Subsequently, recollection. He what he had saw something, he has seen some document, he must recollect it. When once he has recollected it, he will be able to communicate. He should come and say. So, for refreshing memory, these three postulates are necessary. One is observation. Secondly, suppose we go, some people will observe everything, some people don't observe anything. Suppose when we are going, some crowd is going, some crowd is going, some will go. Some will say, some in that lawyers are there, judges are there, some experts are there, some other will examine. So that is what is called observation. That is what is called observation. Suppose that is what is called observation. When we see any scene in movie, we see what type of shoe they wore, what type of who among them who is dancing well, who is singing well, like this. These things are, that is what is called observation. Observation, when once you observe something, you should recollect. When once you recollect, subsequently you will be able to know, you will to speak out it. So the experts are two categories. One is general witnesses and other is expert witness. General witnesses means maybe anybody, he may come and give evidence on oral or written. And expert witness means some treatise may be there, some fingerprint reports are there, blood reports are there, some post-mortem reports may be there, some other documents may be there. Those things are required to be produced in the court, and they will. So, however, the evidence, so for that purpose, in order to refresh memory, sufficient time is given to these experts, and they take their own time, remember it, and will give the evidence. So, when once, if Suyamoto, they keep it and give it, it is okay. And if they want to take some documentary evidence, they want to verify some document, they want to refer those documents, they must identify the document. For document, his own documents or other document, all these aspects, section 163 will speak. Then 164 will give chance to opposite party to contradict the evidence given by the experts also. This refreshing memory. The witness, the evidence collected out of refreshing memory can be questioned or contradicted, and the opposite party may demand corroborative evidence or written proof for the evidence given by the under refreshing memory, that is 164. These are the various issues relating to refreshing memory, dear friends. So here, next topic for there are some simple sections are there. I will tell you about this. Number one, order of examination. So section 143 speaks about order of examination. First cross-examination, re-examination, all these things are there. Next, section 144, cross-examination of person called to produce document. In cross-examination, the witness is giving in chief examination, the witness is made some statements. Then opposite party after his turn he will come. You said so many things. Certain you made certain statement. Show me the documentary evidence. He will ask. So in examination of witness, my witness gave evidence in my favor. That is only our statement. The chief examination is over. After chief examination or re-examination, general examination over, then the cross-examination will tell. That opposite party, lawyer or party, sir, in chief examination, particular witness said so-and-so statement. Can he give any written proof? Can he give any corroborative evidence? Is what this man can give. So here, in that process, when in cross-examination, one documentary proof is required, then this man will tell, so this document, yes, this document is there. This document is available with some so-and-so party. So the court will ask that, order that party, that another person to come and bring that document. So when a person is required to bring some document to the court, he is only person who is providing document only. He is not a witness. When we are calling, what we need is only document for verification. We don't we have to check the document, contents of the document, whether the contents of the documents are consistent with the evidence by the witness in chief examination are relevant or not. We have to question. But we are not bothered that the person who brought the document is not a witness. He should not be questioned. So then if the party asking of the court to that part want to question, that means the court will not allow. So the witness is different. The person who brought the document is different. Then another thing is, when a document is required to be produced, the document may be in favor of some particular person. That person, by production of that document, it may cause a harm. So such, according to one section, such any document produced, any statement made, if any person called for give evidence, you should not give any, it should not affect his character, you should not criminate him, you should not put him criminal liability. Even for that also, certain things, the character also can be taken into consideration, immorality of can be questioned. Generally, scandalous questions cannot be questioned. Abusive questions should not be questioned. Questions affecting character should not be questioned. Questions affecting, suppose the questions are put in that process, the reality is come out and the person is has to face criminal liability. Such questions cannot be questioned. So these are various rules are provided in various sections. According to, so when in cross-examination, if any document is required to be produced, the person who brings the document should is not a witness, he should not be questioned. So accordingly, there are some other sections put to say he is not witness. And when a person when the party does not like to produce the original document, he should not make use of that document in future. When once calls for any person to come and witness, he refuses to come and give witness, court may take any action. If the court may take any action, he may refer the matter to the some authority to take necessary action also, that is there. So here evidence has to matter in writing. Sometimes the witness who is telling, he is making some statement, he may be required to show the documentary evidence. You are telling that you are making this statement. Can you can you prove it in writing? So this is one of the fundamental principles of law of evidence is the best means of evidence must be produced. What is the best means of evidence? The best means of evidence or primary evidence is document. The document is produced. In the absence, that is why documentary evidence is superior to oral evidence. Documentary evidence is superior to oral evidence. Documentary evidence is the best means of evidence. When once oral statements are made, the court can insist the witness to prove to present any documentary. So cross examination to previous statements in writing. So in cross examination, when a person makes some statement, the opposite party will come and he wants to contradict it. You are giving this particular statement. Can you show anything in writing? That also can be questioned. So when you put question, the questions must be lawful in. They must you must put only lawful question. You should not question an unlawful question, illegal question, embarrassing question. Section 149. And when a person is compelled to be when a person is compelled to give evidence, when a person compelled to come to court and give evidence, the court has power under section 150. And the court has discretionary power according to section 151. What questions shall be put, what questions shall not be put, what when the witness shall be compelled to come and answer, when the witness should not be compelled to answer, the court will decide. So then questions not to be asked without reasonable grounds, section 150. So when a question is asked, certain questions should not be asked on reasonable grounds. Sometimes some bad questions also may be, scandalous questions may be asked. Questions opposed to public policy also may be asked. Suppose a prostitute, a prostitute's character comes into question, but she makes some allegation, and she claims the legitimacy of child to invoke property. Then to establish the illegitimacy of the woman, there her background character, her affairs with some other person also may be questioned. These are the various issues that come within the course of the examination of witnesses. So these are the various issues relating to examination of witnesses, and among these you have to take into consideration these main points: leading questions, impeaching credit of witness, hostile witness, refreshing memory, and all. Dear friend, thank you very much for your patient hearing. So far as this Bharatiya Adhiniyam is concerned, I have covered almost all the topics. And why the heading is Civil Judge Junior? Because this law of evidence I gave three lectures, these three summary lectures, and completed it long back. That would be enough for LLB student. When once I started the lectures with the title Civil Judge Junior, I have taken lot of number of lectures from Bharatiya Saksha Adhiniyam. But so far as the Bharatiya Saksha Adhiniyam is concerned, almost all the sections and contents remain unchanged. There are only slight differences. What are the various differences? I am telling from time to time. In the beginning classes also I told you. So in this Bharatiya Saksha Adhiniyam, I will take up in next class burden of proof. It is a very important chapter, and some one or two miscellaneous topics are there. Within I will burden of proof I take one class. For miscellaneous topics, whatever I left, I will take one class in simple things, and then I will proceed for comparative study. Then we'll give some general lecture about various aspects of our regular course of life with reference to my practical knowledge. So in my previous lectures I was telling you, I try to watch my videos and attend some coaching center for 6 months and directly compete for the post of judge. I told you several times, but it is learned from reliable sources that the Supreme Court of India has gave directed to insist 3 years practice standing as a condition precedent. After enrollment of LLB, one must act as advocate for 3 years. Then only he will be eligible for the post of that. But how far it will be, whether it may be challenged or not, we have to think. So wish you all success. God bless you.